Today's session is going to be focused on probate. I have with me today, I'm always thrilled to have attorney Deborah with me. She's a probate attorney that I've been working with for at least 7 or 8 years now. So a lot of probate things that land on my desk as a real estate agent, as an investor, I'll run questions by her as she's in the field on a day-to-day basis doing probate stuff. So by all means, let's give attorney Deborah a round of applause. And
hello, everyone.
Thanks for joining us. And by all means, feel free to give us an introduction. Tell us a little bit more about yourself.
Hi. Okay. So as Emil said, my name is Deborah White. I have been practicing for almost 24 years, mainly in the area of probate, and I also do some family law. So I've probably dealt with so many issues, and as a matter of fact, you know, we learn things every day because different issues come up. But, you know, the probate area has a lot to do with the probate trust, you know, and, you know, some other areas that are not as linked to selling the properties, but a large part of it, because most people own real estate. And so a lot of times when we have probate, it's the selling of the real property that comes up. Between Emil and I, we hope to give you guys a background on what's involved in probate from the beginning until the sale of the property, where you guys as realtors, most of you your role would then end at the time the property sells.
Awesome. All right, so we are ready to rock and roll. We got the truth about probate. That's what we're going to talk about. Probate. I'm going to read this and then I'll let attorney Deborah expound. But probate is the legal process of administering the estate of a deceased person. Probate is most often the result of someone dying without a living trust.
Right. So, you know, every day the court is bombarded with probate filings where if you have choices. If someone owns real property, they should make some consideration to getting some sort of probate planning done. So that would include a will, a trust, or they do nothing. I always say it's 3 things. You do nothing, you have a will, you have a trust. So if you do nothing, you end up in probate. If you have a will, you end up in probate. And if you have a living trust, it bypasses probate, so you do not end up in the court. So let's say you do nothing or you have a will. The probate process is where you have to file your petition. It generally takes somewhere from 1.5 to 2 years, sometimes 3-4 years. It just depends on what the issues are with the property or with the heirs. And the probate process will end up costing a lot more because it is set by California law. So you not only have fees for appraisers, you've got attorney's fees, you've got court fees, you've got a lot of fees that are involved. And so when you add up all those fees, you will pay a lot more than if a person had thought about it before and said, hey, let me make preparations, like let me get a living trust done. And the thing is that the cost for the probate is based on the percentage of the value of the estate. So if you have a home that sells for $400,000 or $600,000 or $800,000, the California law sets the standards on what percentage the attorney's fees and commissions are going to be from that. The attorney gets a fee and your administrator gets a fee. So that's why it's a much more costly process for probate. But that's a general just overview.
Now, how do we try to prevent that? There are different ways to hold title that often kind of give you the option to navigate through probate, meaning that if you hold title a certain way, you won't end up in probate. Let's look at some of those options. So we have, of course, a sole owner. And you know, this is something that we kind of learn when we're studying for our real estate license. And then, you know, after that is kind of like, well, you know, the title person will help you with that, or escrow will help you with that. But we have sole ownership, which is a single man or woman, an unmarried man or woman, a married man or woman as his or her sole property. Sole and separate property, that is. So I know one time I asked someone, I said, what's the difference between a single man or woman and an unmarried man or woman? And of course, the difference means that one is now divorced, meaning that they're unmarried, and the single person has never been married. But those are ways to hold title, it's sole ownership. Then you have the tenants in common. You have the joint tenants, which I know a lot of times parents will say, oh, I'm gonna put my child, my grandchild on title with me as a joint tenant, for succession purposes. And you know what, I'll pause it there because that's a good little tee up for you, Attorney Deborah, to see like what's your thought on that? Like when people do that, because I know that's very common.
When they put it in joint tenancy?
Joint tenancy to kind of as a means of kind of estate planning and for succession.
Right, right. And you know what? It joint tenancy can work if it's just a husband and a wife and you don't have any children. So the thing is that I tell people to remember, it's like you have to think about building your wealth or carrying your home further than just you and your spouse or just you. So if you're doing it in joint tenancy and the first spouse passes away, there's an affidavit that's filed and the next spouse will then become that owner. But that next spouse now still steps into the shoes of having to make some kind of preparation, or that real estate will still end up in probate. So on the face of it, the joint tenancy, and it's historically been done with, husbands and wives. Sometimes it's done with people outside, siblings or other people, but it's only one step away still from probate. Because if the husband and the wife still don't make some kind of estate planning,
Yeah.
either that wife or that husband is going to end up in probate over that property if they don't make an individual estate plan.
Gotcha.
To that property is still going to end up in probate.
Eventually,
so
yeah.
For a while.
You said it worked for a while, but it
Mm-hmm.
ended up in probate, right? And that's the thing to kind of keep in mind. So like with joint tenancy, the both have an equal ownership in the property, and then when one passes, it goes to that other person.
Yes.
That other person would end up having 100% ownership in
Right.
the property. Whereas with joint tenants, when one person passes, it goes to that person's heirs or whoever they've kind of set aside or designated as their successor or beneficiary for the property. So that's the biggest difference between joint tenants and tenants in common.
Right.
A lot of times people will use that joint tenants as a means of succession, but as Attorney Deborah pointed out, it's a matter of time before you're going to need that living.
Right. And you end up in the same place as a joint tenant.
As a joint
It
tenant.
just takes one spouse passing away or one owner, half of the owner passing away, and you find yourself in a joint tenant a tenant in common position anyway. Because
Gotcha.
if you don't set up plans for it, it will still have to go under California law.
Gotcha. Yep. The other way is a community property. That's very common, community property with right to survivorship. And those two are for married couples, by the way. It's community property or registered domestic partner. I think they
Right.
may apply to both now, right?
Right. If you list your property as community property, or sometimes you don't even list it as community property, but your husband and wife, and so that when one spouse passes away, the other will claim it as a community item. So if you list it with community property with right of survivorship, you can claim that property without ending up in court. But again, joint tenancy, community property with rights of survivorship is only one step away from still having to probate. Because it's the same idea that if it's the husband or the wife, just like in a joint tenancy, and one passes and the other claims, that person still needs an estate planning or that property ends up in probate. If they have children, it ends up in probate, or even no children, if their family members could take it, a parent, cousins, brothers, sisters. So the important thing is a lot of times real estate people are the first persons to come into contact with people that may need help in setting up an estate plan. They may come regarding their property they already own. They may want a loan. And so that's why people that are lenders, realtors, you guys are like the first contact person that are able to tell them, hey, you really need to set up some sort of estate plan. I know you want to, you want to get a loan on the property but when you're done getting this loan, this property you should consider putting this property in a trust because it'll protect you and your family down the road. So you guys are definitely the first contact.
Great. So we have our partnerships, LLCs, and corporations, which is another way to hold title. And
Right.
I think the thing about the partnerships, LLCs, and corporations is there are different operating agreements and things of that sort that kind of spell out who's the signature or the signer of the entity, as well as what the succession is if something were to happen, who's kind of next in command. That is usually what's spelled out in your operation agreements.
Yes, but somewhere along with an LLC or a partnership, somebody may own, if a partnership and it's two of you, somebody owns 50%. So that person's 50%, if the partnership is not set up in a way already that says, hey, it goes to this next person, or it goes to a spouse, or it goes, you may still end up, again, if when it falls down to that last person, you may still end up in a probate if you do not have estate planning, if you do not have any set plans for who your partnership interest should go to, or who your LLC interest would go to, or who, the corporation may be owned by someone and shares may be given out. But a lot of times, if a person dies, their share will go to their family member, their spouse or a family member. So the people still need to make plans for those things.
Gotcha. That's good to know that even with the partnership,
Right.
or corporation, it needs to be spelled out for that entity as to how the succession works.
Exactly.
We have our trust, which is pretty much we're talking about living trust here. Our seventh.
Which bypasses probate, and the trust will have the wishes of the person, and it bypasses probate. You can list your real estate in it. You can list your personal property. You can say, hey, I want my son to have my Rolex. I want my daughter to have my fur coat. I want Aunt Jenny to have my China set. It can be really specific to the items that are important to you. Some people have coin collections. Some people have, old antique furniture. Some people, and you can actually say in your living trust what you want done with all your personal items that you've collected and paid for. If you want things to go to charity, you can say that. You can choose who is going to be in charge of it. If that person can't do it, you can set up an alternate, and you can specifically say how you want your assets divided. And you can say, hey, I don't want Bob to have anything, or I don't want John to have anything. Whereas if it ends up in probate and it's under the California law, someone can be estranged from someone for 20 years. And if they are a parent, a sibling, a cousin, a blood family relative, they can inherit your estate if you make no plans.
Yeah. And I think this particular sheet right here of how to hold title, like I know when you're in escrow, when you open escrow on a property and they hand it to you, a lot of these points aren't what you're thinking about. But
Right.
just one simple decision, and of course that's going to determine how the home gets recorded, will play and have implications about how things will play out 10, 20, 30, 40 years from now, 50 years from now. If you check the tenants in comment box and it never gets amended, and someone hypothetically never refinanced or changed title, then that's how things are going to be treated when the time comes. So how you hold title is ultimately the starting point, and that needs to be definitely spelled out so that there aren't any mishaps or probates that weren't intended down the road. So definitely wanted to start with this because this is the meat and potatoes, I think, of probate. So a will is a written legal declaration by which a person names one or more persons to manage his or her estate. One thing I always like to point out is that a will will go through probate. So if you have a will, I know a lot of times people think, oh, I got a will, I'm covered, I'm good. But if you're trying to prevent probate, you need more than just a will. My recommendation, if you have real estate or assets that are over 166,000, is to have a living trust. Now let's look at the definition of a living trust. A living trust is a written legal document through which your assets are placed and then transferred to designated beneficiaries at your death by your chosen representative, a successor trustee. Got it. So you kind of have already appointed who you want. It's not like the successor trustee is making the decision, but the difference between these two is a will is just a document. It's, you know, it's just some paper that we have. That's the will, right? It's just some paper. Whereas the trust, it's written as well. It's paper also, but it's paper that creates an actual entity. And then that entity holds the stuff. And then you appoint someone, the successor trustee, to kind of administer how you want things to play out upon your passing or upon whomever is passing. That's kind of my understanding, layman's way, but at least the way I kind of grasp it.
Right. No, that's good. And again, the biggest difference between the two is that you end up in court with a will. It's good you have something, but you still get the same expenses. You still get the same costs for the will, and you get the long year, 2 years sometimes with a will. You know, so whereas the living trust is instantaneously. If a living trust comes into play when a person passes away, you don't have the delays. You can contact a bank, you can contact the realtor, the title company. Everyone will ask for if you're trying to sell that property, will ask for a copy of the trust. Whereas the will, you have to go through probate, you have to wait, you have to get court permission most of the times to sell, and that depends on how you take your title. So in the will is a lot. It's great to have something, but it's still very, very limited. And I think you were going to go to the next slide that shows the different types, Emil.
Oh yeah, I'll get to that in a second.
Okay.
I didn't want to interrupt you. Go right ahead. That was,
So,
I kind of like with the mouse accidentally clicked on something.
yeah, it's okay because it comes right into what I was going to say anyway. There's different types of a will is a will, but there's different types of trusts. Gotcha. So as Emil has listed here, there's revocable, irrevocable, the AB trust, and the special needs. So a revocable means that you can make a will, and anytime during your lifetime, you can make changes. You can change your mind and destroy it if you want. You can cancel it, or you can make changes and add to it. If you had one piece of property when you made the trust, and you end up getting one or two more, you can add it to your trust. If you decided that your kids were underage and you had a trustee, you can change your trust now that your kids are older and make them your successor trustee. Or if a successor trustee that you listed passed away, you can make a change and put a new trustee in. So the living trust, the revocable living trust, allows you to make changes to your trust during your lifetime. Upon your death, it becomes irrevocable. So then the next one is the irrevocable. A few people choose, it's way less than a revocable. Some people choose an irrevocable trust. And I always tell people to be really careful, because once you've done an irrevocable trust, it's irrevocable. You can't go back and make the changes that you want to. Now, if you may hold the power to maybe change your trustee, but not your provisions that you've put in there. So I'll just give a simple example. You put in there, oh, I want my two kids to share the entire estate 50-50. And then child number one is doing great, and child number two, unfortunately, gets hooked on drugs. So now you have an irrevocable trust where child number two will collect hundreds of thousands of dollars that they will blow on drugs or whatever on the streets and not really have funds to take care of themselves. Whereas if you had a revocable trust, you would say, hey, you know what? I need to go make a change. And I'm going to say that son number one is going to collect 100%, and then they're going to take care of son number two. Or son number two, one will collect his 50%, put his brother's 50% in an account, and pay out his living expenses every month. So it helps you to carve out, because life changes and things occur that we don't think about. So a revocable trust gives you that opportunity to move and change with life. An irrevocable trust doesn't do that. And then the third one is the AB trust, which generally is done between husbands and wives. So, or partners, and, now, we've changed some of the categories. So it's done for partners and husbands and wives, and so when A may be the first spouse, B may be the second spouse or partner, and when the first one passes away, there's instructions on what happens with the trust, and the distribution doesn't occur until both A and B passes away. Then it would get distributed to their children or their relatives. The thing about the AB trust too, it is a revocable trust. So you have the ability to make those changes during your lifetime also. You have the ability to revoke it. You have the ability to change it. You have the ability to, just make it work for your changing needs. Some people age, and again, their trustee may pass away, or they have dementia or Alzheimer's, and they can't function as a successor trustee. So you have to go in and change it. So this allows you the ability to change, just like the revocable. And then the last one is you have your special needs trust. And a lot of times that's for, when you have handicapped children, family members, and you have to set up a trust that, that really takes care of their special needs. And it's set up around provisions that they may get from the state and the county, because sometimes if the state or the county are providing like a school or funds or whatever they provide for that disabled or special needs child or person, they can take those things away if they find out that they've inherited money. So, they work those special needs trusts a lot of times as much as they can around those things, but they're generally for a child or an adult, that will not be able to take control of their funds, when they become of legal age.
Gotcha. Now, a lot of times I see the AB trust like for blended families.
Mm-hmm.
There was a prior marriage, or maybe there's children by different parents. Is that what you see, or is it not always like that?
Well, it can be used that way sometimes. It can be, but whether it's a blended family or just a family with a husband, wife, and kids and no stepchildren or anything, it would still have the same effect, because you are still making provisions for that once that first spouse passes away. And then you will make provisions until that second spouse passes away. And then the children will inherit, whether they are children of that marriage or children from either former marriage that belong to the husband and the wife. Now, I came across something interesting recently where I've never really had to deal with, but one party, the husband, had a lot of separate property. And so in the AB trust, he specifically left those properties to his children. And so right now, instead of waiting until the wife passes away, we're working on distributing all the husband's separate property from that AB trust, when an AB trust is generally not distributed until both spouses are gone. So I told my successor trustee, I said, the wife should sign off, the children that are collecting should sign off, because it's generally you wait until both spouses are gone before you distribute that trust.
Gotcha. Yeah. Well, I know we've been talking about wills will go through probate, and the best way to try to prevent that is by having the living trust. And this slide talks about the different types of living trust. But a question I wrote down for you, kind of a bonus question, is how often do you see a trust end up in probate?
Um,
Because I mean, I'm guessing because they get contested sometime.
right. They do. They do get contested sometimes. A lot of the times they're being contested over the provisions. Sometimes it's the validity of the main, the number one reason that you would get a trust being contested on the validity of it is that an heir feels like they have been left out, right? Or they didn't get the share that they thought they were going to get. So it can happen quite often, but the courts really stay close to the intent of the drafter of this trust, which
Okay.
is the husband and the wife, or just a single person. They look at what your intent was and what your desires were in that trust, and they will not deviate from it. So people can bring it, but the court will honor a person's desire and intent in that trust as much as they can read and clarify in that trust.
Gotcha.
The other thing is that sometimes sometimes people will argue over whether or not someone had capacity to make that trust.
Okay.
And if they cannot prove there wasn't capacity, then they have a hard time overturning it. They would have to go and get medical records most of the times to show that a doctor wrote in their medical records that they had dementia or Alzheimer's.
Okay. Gotcha. Good points there in that respect. I know we've been talking about wills and trust and probate, and I want to kind of look at the cost, because I know Attorney Deborah mentioned it in the beginning that, of course, probate is a lot more expensive than setting up the living trust. I know a lot of times when I have this conversation, it's about, hey, have you thought about putting your property in a living trust? And they say, well, how much is that? And then they hear the price, and they're like, oh, I don't have that right now. Or do they take a plan kind of thing? But
right. So, the cost of a living trust varies, and it can go somewhere upwards from $2,000 or more for a single person, depending on the number of properties that you have, to somewhere between 35. It just kind of depends. If someone has one or two pieces of property, you're on the lower end. If someone has, I've known some lawyer friends that have charged up to $5,000 because someone has 10 pieces of property. And, if you've got somewhere in the mid-range, 3-4 pieces of property, you may be in the mid-range at about $3,000 for a trust. But when you compare that to the cost of probate, you are talking about, for a minimum probate, you're looking at probably somewhere around $20,000, 50, it's somewhere up and above that, because it's done by the value of the estate. So, and when you pay out just the attorney's fees on the value of the estate, that doesn't take in the list that Emil just put up, your publication fees, your probate referee fees, your filing fees. And again, if your attorney gets, like for instance, a $23,000, your personal representative is going to get the same thing. So the typical cost of a probate is extremely expensive.
So in this example, and I don't know if the numbers have been updated. I haven't looked since I made the slide some years ago, but when I did before, we had this estate and it was valued at about $1,750,000 for the home, and then $250,000 for the personal effects, accounts, investments, things of that sort. And the overall cost, as you can see, was about $48,000 was the probate cost, and it was a combination of the things listed. But there are also, what's it called, extraordinary fees?
Extraordinary.
Extraordinary fees that can go on top of this. Can you speak to some of those extraordinary fees?
Yes. So I guarantee you there will be extraordinary fees, because especially if it involves a real property. So anything that is not in the straight realm of the probate, And it's additional. The court allows the attorney to bill
Oh, right in the middle.
on two categories. One is statutory, one is extraordinary. So the statutory is the one that's set by the value of the estate. The extraordinary is by the attorney's hourly rate. And those are for things that fall outside of what the court considers the straight probate process. It could include an eviction. It includes dealing with the process of selling the property. It can include any problems you have with the heirs, anything that is outside the straight probate process, will end up being extraordinary. For instance, you have to deal with opposing counsels on issues. I have one property right now where one of the heirs is living in the property, won't get out. Property's been sold. She hired an attorney. I have to deal with the attorney. All those things are billed at extraordinary because they're outside the normal process of going through and processing the case through the courts.
Gotcha. So when we look at this 48,000, this is just a starting point.
Right.
It could very well be more than that when you
absolutely, because your publication fees, that's like a general. Emil and I know we have houses that we have one for instance, in San Bernardino, and that probate fee publication fee was almost $1,500.
Oh, wow.
Just the publication fee. That's the Richards file.
Gotcha.
Yes.
Yeah.
It was almost $1,500 just for publication fees. And you have to publish several times during the
Yes.
case,
Yeah.
depending on the type of if you get full authority or limited authority.
Yeah.
I always recommend that people get full authority, which allows you to sell the property without having to go back in for court confirmation. If you get limited authority, you have to go in and file a petition and wait for a court date and get court approval for any sale or anything else that you want to do with the property. And a lot of times the reason that people end up only taking the limited is, one, there's no real property. Two, their credit does not allow them to get the higher bond. Bond is insurance. The court generally makes the personal representative insure the estate, because believe it or not, people who are in charge of the estate have sometimes walk away with the money or misuse the money, and so they have to, they insure the property to protect the heirs. So there's a lot of, fees that can be higher and different.
You brought a good point up in regard to limited authority versus full authority. Like, of course, as a buyer, as an investor, as a real estate agent, on either side, whether you're listing the property or you're representing the buyer, we like to see full authority. Limited authority definitely means that it's going to take longer. We have to go back to court. The property could be subject to overbid. Those are things that definitely will come up more often when there's limited authority. Now, you had mentioned the distinction, like, is there pretty much a way to kind of ensure that the PR gets full authority, or it's just kind of left?
Right. So generally what happens, if I see that an estate has real property, so a lot of times people will say, no, Deborah, I want to keep it. I'm going to keep it. I always try to advise them that in order for you to keep it, no problem if that's what you want to do, but in order for you to keep it, you have to qualify for a loan. So if a property is valued at 600,000, 700,000, 800,000, 500,000, 600,000, 700,000, and there are multiple heirs, or there's only one more heir, you still have to take out enough money to cover all of those payouts, plus the cost of probate for everyone. So a lot of times the hard part for people is to qualify for a huge loan, depending on what their financial situation is. I always tell people, hey, you know what? It's better to get the full authority in the beginning, because just in case you cannot buy this property, then you've already have the full authority to go ahead and not hold up a sale on it, so that you can have the control over the sale, choosing a realtor, signing all the papers, and getting the property sold.
Gotcha.
Whereas if you only had limited because you said, oh, I'm going to buy it, so I don't want to pay the higher bond on it. And the bond is once a year, and it is higher if you get full authority, but the estate will reimburse the personal representative, or a lot of the times we pay it out of the sale of the property. Once we get the check in the bank, we'll pay it out of the sale of the property.
Gotcha. So there's a lot of good information here on this one. We're talking about the cost for probate, of course, the bonds, the extraordinary fees, things of that sort, authority versus limited authority. You will hear that time and time again when dealing with probate real estate. Absolutely. So the cost for a living trust, as was mentioned, living trust, and this is for the revocable living trust, typically somewhere maybe between $1,000 and $3,000 for a single person, married couple between $2,000, $6,000 on average, depending, of course, what's a part of that person's estate plan and living trust. Of course, if somebody has 15 properties, then that would be a higher cost versus somebody who may just have the 1 or 2 properties.
Right. And let me clarify on the single person at the $1,000. Most likely any attorney that you deal with is going to be somewhere upwards of $2,000 for a single person. And the reason is if you go and you get a living trust for $1,000, generally you only get the living trust. Like an attorney like myself, we're experienced enough to know that simple living trust doesn't cover you, because a living trust doesn't come into play until a person dies. So what happens if a person gets Alzheimer's or dementia before, or they're in an accident, they're in a coma, they can't function, they're alive, but they can't function in the same way. So that means that you need to have other things in place. You need to have power of attorney for healthcare, power of attorney for finances, and so all those things may not be included in just the living trust by itself. So I generally will include a packet, which is a power of attorney for healthcare, power of attorney for finances, the living trust, your pour over will, and the preparation of the deed for your real property. Because if you don't transfer that real property to your trust, if it's listed in your trust, it's okay, it's listed, but you still have to go to court. Your successor trustee will have to go to court, file a petition to bring that property into your trust legally by an order of the court. Whereas if the deed was prepared and filed and everything was taken care of, you don't have to go through that. Right. That's why a lot of the times people will sometimes go to someplace else, a bank or a service place or somewhere that may just say we do living trust, but they don't understand the legality of all the things that may be missing.
Right. So, we've seen that several times where, the property is still in the deceased name, but the person has a living trust. And so then that's where you have to do that petition. It was a Hegstead. I always mess up the name.
Yes, a Hegstead petition.
Hegstead petition. Yeah. So you always, that's the kind of like the way to put the house in the trust, but right. To make sure when you do the living trust that you re-record that deed. Remember one of the very first slides we talked about is how to hold title. So when you pull up the property profile, that title profile should say, Mr. Michael Chair, living trust, Michael Chair family trust. Like that should show up as the owner of the property, because we've taken the property and put in the trust. So that's important. That's a very important piece of the puzzle not to forget when dealing with trust and estate planning and things of that sort. And it circumvents that need to increase court fees by doing the Hegstead petition. It's already taken care of. So it's very important. Now, probate is here to stay, right? Why? Because 10 out of 10 people will die. So the question is, how are you going to handle your affairs while you're here? And as we just pointed out, we know a lot of people don't. So probate's going to be here to stay. And it's definitely one of those things that as a real estate agent, as a real estate investor, it's good to kind of have some knowledge and understanding of the workings of how those things work in regard to probate, because it's going to come up. 80 to 90% don't do it. The death rate, I'm not exactly sure what this meant in 2007, death rate. And then in 2017, it was an 8.5. But I guess that meant that the population may have been aging, so there was more in that regard. How that statistic was come up, I didn't get into the calculation, but I did notice that it was going up. And of course, the most valuable asset in most people's estate is the real property, is the real estate. You know, in that $1 million example that I gave a few slides back, 750,000 was the real estate. 250,000 were assets and things of that sort. Usually the real estate is definitely a big part of the person's estate. So probate properties usually need some TLC, not always, but usually need some TLC. They could be a little dated, and they're usually being sold by the heir. Just a kind of note to self there on that one. I know we're getting close to our time. I told you I'd have you kind of wrapping up right around 2 o'clock. So I wanted to make sure that I got a few things in. How can we work together, specifically you and I, on things? Well, number one, I'm a probate specialist. I, work with like Attorney Deborah, and I have another slide of probate title rep that I often run things by. I'll put his information up here as well. So feel free to refer listings. If you have a probate listing that I can work on, I'd be happy to consider co-listing with me. Consider me a consultant if you come across a probate, you want to do it, but want to reach out to somebody. I'm also an investor, so represent me. If you have a probate, feel free to write up the purchase contract and show me the property first, and if the numbers work, then write up the contract and represent me. You will need a probate attorney, no question about it. I wouldn't try to go through probate by myself. I wouldn't use some document preparation service, me personally, especially if it's an involved probate. Probate resources for you. Mike Torres Institute, he has a probate session to kind of get certified. This is for people that are real estate agents, maybe a real estate investor wants to know a little bit more, but definitely real estate agents and brokers. Mike Torres Institute out of Long Beach. I went through his session, I think that was around 2013. Very enlightening. That helped me understand what was going on. I did a probate case, and I was just kind of stumbling and fumbling through it because title was helping me through it, but I didn't know what the letters of testamentary were. I didn't know what the letters of administration were. I didn't know the difference between an executor and administrator. These terms really didn't resonate with me. After I did Mike's probate training course, I think it's online now, crystal clear, and then of course being connected with Attorney Deborah, made me a really good resource in regard to probate. Kevin Sells, he's a title rep. He does title. Again, you can take a screenshot of these things when they come up, and he's a great resource in regard to probate and probate titles. These are some people that I've used in the past, I recommend. And of course, Attorney Deborah here, I have her office number down in regard to if you need a probate attorney, you have questions about probate, by all means, feel free to reach out to her. Thank you very much, Attorney Deborah, for joining me. I appreciate you making the time. Let's give a round of applause, everybody. And of course, thank you all for being here in today's session.